Of course, you want to know when you can legally use deadly force and not get in trouble. Hi, I'm Kevin Michalowski. I'm Director of Content for the U.S. Concealed Carry Association. And if you watch this video all the way to the end, you're going to get an opportunity to win a free gun. I'm here today with noted criminal defense attorney Tom Grieve, former state prosecutor as well. And we're going to talk briefly about when you can use deadly force legally. When, and I've been working with you long enough to use legal terms, when are you privileged to use deadly force? Tom, let's talk about this.
All right. Well, number one, check your local listings. Laws are going to vary from place to place, jurisdiction to jurisdiction. Generally speaking, though, you need to be facing some sort of deadly threat before you can use deadly force. So in Wisconsin, we have to be facing a reasonable fear of imminent death or great bodily harm before we're going to be privileged to use that deadly force back. Big picture, that's what it's all about.
Yeah, when we start hearing words like imminent, that's when I usually say send in the lawyers. You're here. So what would make a threat imminent? How do we get to the fact where a reasonable person believes that this threat is happening now and I need to use deadly force now to stop it?
Well, do you see the attacker? Are they making some sort of threat? Are they brandishing that firearm? And does it look like they're about to act as well as have the capacity to do so? That doesn't have to be the only formula or the means of expressing those ideas, but it certainly gets you there. So basically, they got to have the threat and the ways to deliver that, to act on and deliver that threat, and they got to be able to do it now.
The example that we always use is a guy with a machete standing 20 feet away from you. He is an imminent deadly threat.
Yes.
Same guy, same machete, 20 feet away from you, but he's on the backside of a 6-foot chain link fence and he can't get to you. I can't shoot that guy, can I?
Probably not. No.
Yeah,
I mean, right.
Yeah. You as a prosecutor would have said that threat is not imminent. It is not something that is he has no means to carry out the threat. Even if he's hollering, "I'm going to kill you," you can't use deadly force to stop.
Especially if we make that 6-foot chain link fence, say 20 foot, and put some barbed wire on top of it. Yeah, absolutely. I mean, those are going to be factors that are going to be able to delay the employment of that deadly force against you. And therefore, look, that isn't to say that he cannot become a deadly threat. For instance, he scales the fence and starts coming back down the other side. Different situation.
Yeah.
The machete guy goes Indiana Jones, pulls out the firearm. Different situation. We now have new facts, new fact patterns, new situations, which means the law and the application of it, well, the law stays the same, but the application now it varies.
Now, I really liked one term you used there, factors. We talk about victim-subject factors. Now, let's just say the guy is 6'4" and really well built, and he's wearing a, Michalowski's MMA gym T-shirt or something of that nature, and you reasonably believe that this guy, though unarmed, could cause you death or great bodily harm just with his fists and his feet. Let's assume, for the sake of this discussion, he has made a threat. And I always tell people this: if somebody says, "I'm going to kill you," believe that person.
So we're taking the classic unarmed attacker and when can use deadly force. Look, if you are going to be able to articulate why that person in Wisconsin, the formulation would be, they were posing a reasonable fear of imminent death or great bodily harm, then you are privileged to use deadly force. This is going to be in the eye of the beholder a little bit because reasonable minds may differ.
Yep. You keep saying reasonable.
I know. Well, even unreasonable minds can differ, especially unreasonable minds can differ on it. I wish that this was truly black and white. But it isn't. This is 1,000 shades of gray. Yeah,
and certainly your 89-year-old grandmother can pull out her, old 41 caliber rim-fired Derringer.
Right, I'm tracking you.
And use that to stop the threat if this big guy is going to come and beat the crap out of her and take her purse. And one punch to her could be fatal. One punch from that guy to me probably not going to be fatal, and the jury is going to look at that completely differently. That's why I said victim-subject factors. There's going to be a lot of things that go into this, and truly myriad things. It could be anything from do I have a bad back to do I know that this guy has previously had convictions for assault or something like that.
Absolutely, and unfortunately, I how many of us you grew up playing sports in America? By the time you hit 40, 45, let alone 50, I mean, yeah, your back hurts, your knees hurt, your ankle hurts, everything kind of hurts. Have you actually gotten those documented? Have you actually gone to a physician and been tested and gotten them documented? Because all those subject matter factors that you're talking about, okay, show me the paper trail ahead of time. rather
Right.
than, of course, the paper trail after the incident where, let's face it, a jury's going to look at that, a prosecutor's going to look at that, law enforcement's going to look at that. They're going to say, you know, sounds like he got a fancy attorney or something like that.
Yeah.
So this is the fancy attorney telling you, go out, get these things documented, get them on paper. Look, how many times have we all heard those stories where we've heard somebody say, well, why didn't they just shoot him in the knee or something like that?
Yep.
Don't think that those same people are not going to be on or maybe even trying to get on your jury and bringing that same use of just shiny intellect and lack of knowledge and education is really what it boils down to, because many times they are very intelligent people. They just lack the knowledge, they lack the training, they lack the education to know, okay, that's not a thing. And that's really what it comes back to here.
You have to be facing an imminent deadly threat, and the threat is imminent if the person has a weapon, and that could be their fists and feet.
It could be.
They have intent, and they either declare it outright, I'm going to kill you, or they don't stop coming forward and swinging at you when you're backing away. And they have to have a means to make good on that threat. This sort of delivery system, this ability to kill you if they showed the intent and they have the weapon or the means.
Well, again, you got to keep in mind, check your local listings for the laws. I cannot stress this enough about the fact of we're using imminent. In another state, it might be immediate.
Okay.
So all these different things, you know, they all vary. Obviously, there's stand your ground laws. There's duty to retreat laws. There's sometimes shades of duty to retreat laws. Maybe we can do another video talking about that at another point. But you really, 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 really need to know your laws. You need the education and the training to understand what can you do and what level of force can I use on the force continuum and under what circumstances. Because if you misuse the force because you misunderstand the law, that's going to be no good for not only you, but your family as well.
Yeah, it doesn't help. You got to know what you're doing. And uscca.com/laws, folks, go out there and check that out. We got a great laws page and reciprocity map out there. Now, I told you that there's an opportunity for you to win a gun. So down below in the description, you're going to see a link. You click on that link, follow it all the way through, and you're going to get this chance to win a brand new firearm. And the way guns are selling these days, you're going to want to get out and get on top of that stuff. So thanks again. I'm Kevin Michalowski, Director of Content for the U.S. Concealed Carry Association. Stay safe.